Hi, I'm Michelle Driscoll with Michigan Alliance for Families. Thank you for tuning in to this video about special education evaluation and eligibility. This is the time of year when parents realize their child might be struggling and you want to find out why and what you can do. A special education evaluation may be needed, and it's important to understand how the evaluation eligibility process works. I'm going to be discussing federal regulations and state rules about special education, evaluations, and eligibility for special education services, child find obligations of schools, how to determine if a child may need an evaluation and the process to request an evaluation, what prior written notice means and what is required when a school gives you prior written notice. I'm going to talk about the review of existing evaluation data, the READ, and what consent means and when it's required. I'm going to talk about the first or initial evaluation process and the multidisciplinary evaluation team and who's part of the team. Eligibility for special education programs and services and the IEP, the Individualized Education Program, and parent participation in the evaluation process and IEP meeting are also going to be discussed. I'm going to talk about a notice of a free appropriate public education, FAPE, and procedural safeguards and rights and protections for you, the parent, and the student. I'm also going to touch base for a bit on a free appropriate public education for adult learners and a quick overview of the re-evaluation process. So let's get going. The Individuals with Disabilities Education Act, the IDEA, is a federal civil rights law that entitles eligible children and students to receive a free appropriate public education, FAPE, in the least restrictive environment. I'm going to be discussing these noted sections of the IDEA that you see on the slide. I'm also going to reference Michigan Administrative Rules for Special Education. This is how the federal regulations under the IDEA are implemented in Michigan. The IDEA sets the minimum requirements, so states can do more than the federal requirements, but not less. In some cases, Michigan has a separate rule from the IDEA. For example, the IDEA mandates a timeline from parental consent to evaluate to the completion of the evaluation process and determination of eligibility or ineligibility for special education services within 60 calendar days. Michigan shortens this timeline to 30 school days. 504 plans are covered by a different law, the Rehabilitation Act of 1973, Section 504. The Rehabilitation Act of 1973 is another federal civil rights law for all people with disabilities. In school settings, it ensures access and accommodations to students with disabilities who may not qualify for special education services. This is done through the development of a Section 504 plan. This video is going to focus on the evaluation process and eligibility for special education and related services under the IDEA. I'm going to use the term parent throughout the presentation. Parent, as defined in the Individuals with Disabilities Education Act, the IDEA, is a biological or adoptive parent, a guardian who's authorized to make general or educational decisions, but not the state if the child's a ward of the state, an individual acting in the place of a biological or adoptive parent. This could be a grandparent, a step-parent, or other relative with whom the child lives, or an individual who's legally responsible for the child's welfare. And also a surrogate parent who's been appointed by the student's local education agency, or a person who's been appointed by a judge's order. All of the individuals I named have the same rights as a biological parent to make educational decisions for a child under the IDEA. In Michigan, when a student turns 18, all parental rights transfer to that student unless a legal guardian has been appointed through court proceedings. There are also protections in IDEA to ensure the rights of children who are eligible or suspected to be eligible for special education services when a parent can't be identified, the school can't locate the parent, the child is a ward of the state, or the child is an unaccompanied youth, meaning not in the physical custody of a parent or guardian. and they don't have a fixed, regular, and adequate nighttime residence. The main purpose of the Individuals with Disabilities Education Act, the IDEA, is to ensure that eligible children with disabilities receive a free, appropriate public education in the least restrictive environment that meets their individual needs. This includes special education and related services that help prepare them for further schooling, jobs, and independent living. The IDEA also includes something called Child Find. This means schools must actively look for and evaluate all children with suspected disabilities, no matter how serious the disability is. In Michigan, this applies to children and students from birth through age 25. Schools must figure out which children with disabilities are getting special education services and which ones are not. This includes all children suspected of having a disability, including children who are doing well in school, getting passing grades, and are moving up from grade to grade. Schools are also responsible for identifying all children who might need special education services, even if they aren't currently receiving services. This includes children in public and private schools, highly mobile children, migrant children, children who experience homelessness, and children who are in foster care. For children from birth to 3, the Early On program conducts statewide Child Find activities to locate children who may need early intervention services. Some of these children may also qualify for special education services under Michigan law. The Michigan Department of Education's Office of Special Education works with Early On to make sure these children get the services they need. The Office of Special Education created Build Up Michigan to help locate children ages 3 to 5 who are eligible for special education programs and services. In Michigan, Child Find activities are coordinated by Early On, birth to age 3, and Child Find coordinators for children and youth ages 3 through age 25. When children are struggling in school, it's important to find out why. There may be concerns about language, communication, attention and focus related to work completion, following directions, academic or social skills progress, or behavior, to name just some common areas of concern. If a parent or school professional has concerns, you should not wait to request an evaluation. Early intervention can have a positive impact on the child's development. A child may have a disability that is affecting their educational performance and may need special education and related services. This is instruction that is specially designed to meet the unique needs of children with disabilities. The school may want to try interventions in the general education classroom and change instructional practices to see if that helps before conducting an evaluation for the child. While the school may want to try various interventions, and that's a good thing, it is important to note that the use of those interventions cannot delay or deny an evaluation when there is a suspected disability. If trying different strategies, interventions, and supports that are provided to all children in the general education classroom don't work for your child, an evaluation can be requested for eligibility for special education services. The request for an evaluation can occur at any time during a child or student's academic career. Either a parent or the school may request an initial evaluation when a student is suspected of having a disability. When a request is made verbally, the school must help the parent in documenting the request. If the school does not acknowledge a verbal request from a parent, this could result in a violation of Child Find. We do suggest that parents put their request in writing for documentation purposes. Parents are often the first ones to notice that their child's learning, behavior, or development may be a cause for concern. If there is concern about your child's progress in school and your child may need extra help from special education related services, your concerns can be put in writing or discussed with the child's teacher, principal, and/or director of special education to request an evaluation. When requesting that a child be evaluated for special education and related services, include your specific concerns that should be addressed. While listing specific concerns is not required in the request, it is helpful for the school to know what you're seeing and what your concerns are. For example, if there are concerns related to your child's behavior in school or lack of academic progress, communication, or social skills, if an evaluation is going to be done, the school must evaluate your child at no cost. School personnel may also ask to evaluate the child, and this might be based on a teacher's recommendation, observations, or results from tests that are given to all students. If a school says they would not evaluate your child, they must give you written notice about this decision, and I'm going to get into more details about this written notice next. It's important for parents to keep documentation when you reach out to school personnel regarding any concerns about your child. Within 10 school days of receiving a request to evaluate, and before any evaluation is done, the school must provide you with written notice and request your written consent to evaluate. Prior written notice is a legal requirement of the IDEA. It's written information given to parents by the school to explain an action that the district wants to take or is refusing to take related to a child who has a disability or is suspected of having a disability. There are certain times when the school must give you this prior written notice, such as when they want to or refuse to initiate or change the identification, evaluation, or educational placement of your child, or change the way they will provide a free, appropriate public education to your child. Prior written notice is also required before requesting parental or informed consent for conducting evaluations and the first time your child receives special education related services. The information in the notice will help you make an informed decision about providing consent. Providing you with written notice should be automatic. Sometimes the school may tell you something in a conversation or in a meeting related to the issues mentioned above. It does not eliminate the requirement for the school to give you notice in writing with a full explanation of the action they will take or refuse to take. And if you don't receive that written notice, you can request it. The written notice must describe the action that the school proposes or refuses to take, explain why the school is proposing or refusing to take the action, describe each evaluation procedure, assessment, record, or report that they used in deciding to propose or refuse the action, and explain where you can go to get help in understanding IDEA's laws and tell you how you can get a copy of your procedural safeguards. They have to describe any other options that your child's IEP team, Individualized Education Program team, considered and why those options were not chosen, and provide you a description of any other reasons why the school proposed or refused the action. Some specific examples of when you will receive prior written notice are when you request that your child be evaluated and the school says no, not now, before your child is identified as a child with a disability under the IDEA, before the school changes your child's educational placement, and anytime the contents of your child's IEP team changes. Prior written notice must be provided to you in a language that is understandable to the general public and provided in a parent's native language or in another mode of communication that is used by the parent unless it's clearly not feasible to do so. The Individualized Education Program, the IEP, may be used as part of prior written notice if the document that the parent receives meets all the above requirements. As part of the initial evaluation process, there may be a review of existing evaluation data called a read. The purpose of this review is to decide if the existing data is sufficient or if additional data is needed to establish the child's eligibility for special education and related services and determine the child's education needs. The read process may include a review of the child's developmental and social history, classwork, discipline record, performance on state or district assessments, observations, and information provided by you, the parent. School districts will use a form to document the review of existing evaluation data and the evaluation plan, which will outline what assessments, testing, and observations will be done and by whom during the evaluation process. While the READ process is not required by law for an initial evaluation, it is considered best practice to conduct a READ to collect and review all existing evaluation data about a student before beginning the initial evaluation. Whether or not a READ is used for an initial evaluation, parent consent for initial special education evaluations must be obtained. One of parents' most important rights is the right to give or not give consent for certain actions of the school with respect to their child with a disability. The IDEA requires that the school obtain parent consent, also called informed consent, before conducting an evaluation. Informed consent means that parents have been fully informed in their native language or other mode of communication all of the information about the evaluation for which they're giving consent. And this could include information in Braille or large print. The parent understands and agrees to the evaluation in writing, and that the parent understands that consent can be withdrawn at any time. Parental consent is different from agreement. In the school system, there may be times when parents and schools agree to take certain actions for the benefit of the child, and this may be done orally, and that's sufficient. An oral agreement is not sufficient when parental consent is required. That consent must be in writing. Parental consent to evaluate is not consent for the school to provide special education related services for the first time. It is only to allow the evaluation of the child to be done. If your child is enrolled in public school or you're seeking to enroll your child in public school and have refused to provide consent for an initial evaluation of your child, the school district may seek to conduct an initial evaluation of your child by using mediation or state complaint or due process complaint procedures. This is called consent override, and it's a procedural safeguard that the school can use to move forward with an initial evaluation of your child without parental consent. Schools are not required to use this procedure, and it can only be used by the school for an initial evaluation or re-evaluation of your child. The evaluation process to determine if a child with a disability is eligible for special education related services involves gathering information from a variety of sources, including information provided by a parent about a child in all suspected areas of disability. The information looks at the child's strengths and needs. It may examine cognitive, academic, behavioral, physical, and other developmental factors. Evaluations that are done by medical professionals are different than evaluations that are done by school professionals. Just because the child has a medical diagnosis or a disability does not mean that the child will need or be eligible for special education and related services. A child must have a full and individual first or initial evaluation done by the school. The disability must affect the child's involvement and progress in the general education curriculum, and the child must need specially designed instruction and related services. Of course, medical and other information provided by parents is reviewed and considered in the evaluation process. The purpose of conducting an initial special education evaluation is to see if the child is a child with a disability as defined by the IDEA or the Michigan Administrative Rules for Special Education, to gather information that will help determine the child's educational needs, and to guide decision-making about appropriate programming for the child. There are two parts to the definition of a child with a disability. A child with a disability means a child who's been evaluated and based on Michigan Administrative Rules for Special Education has a disability under one of 13 disability eligibility categories. I'm going to name those in just a bit. And the child who, because of their disability, needs special education and related services. A child who is not eligible for special education services may have a Section 504 plan to address disability-related needs, but will not receive needed assistance under the IDEA. A school team of qualified professionals called a Multidisciplinary Evaluation Team, MET, will conduct the evaluation. The evaluation must be comprehensive to identify all of the individual child's unique special education-related needs, whether or not related to the suspected disability category itself. So, for example, if a suspected disability category is other health impairment for diabetes, but the child also has behavior or communication needs, those should be addressed as well. If appropriate, this will include assessments of health, vision, hearing, social skills, intelligence, academic performance, communication skills, and movement abilities. The evaluation must use a variety of assessment tools and strategies, not just one, and the assessments must be provided and administered in the child's native language or other mode of communication and in a way that will gather the most accurate information of what the child knows and can do academically, developmentally, and functionally. Tests alone will not give a comprehensive picture of how a child performs or what they know or don't know. Only by collecting data through a variety of approaches, such as observations, interviews, tests, curriculum-based assessments, and so on, and from a variety of sources, from parents, teachers, specialists, and the child, can an adequate picture be obtained of the child's strengths and weaknesses. The evaluation must consider information provided by parents. This could include evaluations and reports from private specialists or therapists. The evaluation process must be completed within 30 school days from the date of receiving a parent's consent to evaluate. The school may ask a parent to sign a waiver of those time requirements either before or even after the evaluation is complete, and there may be valid reasons to do this, such as needing additional information that can't be obtained within the 30 school days timeline, but parents have a right to not consent or waive the timelines if they feel that delaying the evaluation process will hurt the child. A multidisciplinary evaluation team, MET, is a team of professionals responsible for evaluating a child suspected of having a disability. The MET gathers informal and formal data to determine the child's eligibility for special education and related services and provide information about the child's present level of functioning. The MET will complete a full and individual evaluation of the child, meet to review information about the child, and prepare a written report to be presented to the Individualized Education Program Team, the IEP Team. The MET must include a minimum of 2 people who are responsible for evaluating a student suspected of having a disability. This could be a psychologist, a social worker, physical, or occupational therapist. The team must include at least 1 special education teacher or other specialist who has knowledge of the suspected disability. For example, if a child is being evaluated for a speech and language impairment, a speech and language pathologist or teacher of students with a speech and language impairment must be a MET member. The MET might also include an administrator, such as a special education director or principal. A general education teacher will share information about how things are going in the general education classroom. The MET may also include additional members based on the suspected needs or disability areas of the child. After the evaluation is complete, the MET develops a report with information about eligibility, present level of academic achievement and functional performance. This describes how a child's disability affects their progress in the general education curriculum, and the educational needs of the child. Parents must be provided a copy of the evaluation report. The MET will make a recommendation about whether the child meets eligibility requirements for special education and related services. The Michigan Administrative Rules for Special Education define 13 categories of disability and criteria for eligibility for each category. The categories are autism spectrum disorder, cognitive impairment, deaf blindness, deaf or hard of hearing, early childhood developmental delay, emotional impairment, other health impairment such as asthma, epilepsy, or attention deficit disorder, physical impairment, severe multiple impairment, specific learning disability, speech and language impairment, traumatic brain injury, and visual impairment. A child must meet the requirements in one or more of the disability categories to be eligible for special education and related services. The disability must affect the child's involvement and progress in the general education curriculum, and the child must need specially designed instruction and related services. Specially designed instruction means changing what is taught, and how it's delivered to meet the unique needs of a child with a disability. These changes help the child learn and ensure access to the general education curriculum. Special education services are provided at no cost to parents, and services are provided by a special education teacher or related services provider and can be provided in any location during the school day as long as it's consistent with the Individualized Education Program, the IEP, and the student's least restrictive environment. The child's IEP team, including parents as a member of the IEP team, determine a child's eligibility to receive special education and related services. After reviewing the information presented by the MET, an IEP meeting is held and the school must provide a parent with the notice of an offer of a free appropriate public education or determination of ineligibility. While the evaluations form the basis for providing special education services, the IEP team can make decisions that vary from the evaluation recommendations if it's in the best interest of the child to do so. For example, maybe a child is eligible under two categories of eligibility. The IEP team can determine the primary eligibility category even if it differs from the MET recommendation. IEP team decisions about programs and services are based on the information from the evaluations, but they are not bound by them. The Individualized Education Program, the IEP, is the vehicle for which that free appropriate public education will be provided to the eligible child with a disability. And again, that free appropriate public education is provided at no cost to parents. The IEP team must include appropriate school and district staff, parents, and the child as appropriate. Parents are an important part of that IEP team. The parent or school may invite anyone else who they feel has specific knowledge or expertise about the child. This person could be a private therapist, caseworker, community mental health supports coordinator, or an advocate. Parents and school each decide who they feel have specific knowledge or expertise about the child. Neither can tell the other who can or can't attend the meeting. All needs identified in the evaluation process must be addressed in the IEP, even if not directly related to the category in which the child is eligible for special education services. If the evaluation results indicate that the child meets the definition of one or more of the disability categories and needs special education and related services, the results will form the basis for developing the child's individualized education program. The IEP team must then develop an IEP focusing on the individual child to address the child's unique needs that result from their disability, ensure access to the general education curriculum so that the student can meet educational standards that apply to all students, advance appropriately towards attaining annual goals, be involved and make progress in the general education curriculum, and participate in extracurricular and other non-academic activities, and be educated and participate with other students with and without disabilities. The time frame from when the parent signs consent to evaluate to the notice of the offer of free appropriate public education or the determination of ineligibility must not be more than 30 school days. Schools must take steps to ensure the meaningful participation of parents in the IEP meeting by notifying a parent early enough to ensure that they can attend the meeting and scheduling the meeting at a mutually agreed upon time and place. The school can't just send an invitation for the IEP meeting the night before. On the flip side, if a parent doesn't attend the IEP meeting, the meeting can be held with only school staff present. So it's very important to attend the IEP meeting so that your parent input is considered and documented. Schools may conduct meetings in person, virtually, or by teleconference, and meaningful participation may need to include parent training on technology being used. The district must do whatever action is necessary to ensure that parents understand the proceedings of the IEP team meeting, including arranging for an interpreter for parents who are deaf or hard of hearing or whose native language is other than English. Within 10 school days of the request for an evaluation, the school must provide notice and request parental consent to evaluate. The time from the school's receipt of the request for an evaluation to the offer of a free appropriate public education or determination of ineligibility for special education and related services must not be more than 30 school days. Within 7 days of the IEP meeting, the school must provide an offer of FAPE and identify where programs and services will be provided and when the IEP will begin. The school and parents may agree to a later initiation date for the proposed IEP if the later date is clearly defined in the IEP. This 7 school days timeline must be within the 30 school days timeline I mentioned before. After receiving the initial offer of that free appropriate public education, FAPE, a parent has 10 school days to provide the school with parental consent to initiate special education programs and services. Parents don't sign subsequent IEPs, only the first time the services, those special education services, will be provided. Unless a parent has filed an appeal, the school must initiate a proposed IEP as soon as possible and not more than 15 school days after a parent's receipt of notification or not more than 15 school days after the receipt of parent consent. This is a document created by the Michigan Department of Education Office of Special Education to visually represent the timelines I just discussed for the initial evaluation procedures for special education programs and services. If a parent disagrees with the results of the educational evaluation of the child, which was completed by the school, the first thing to do is to try to work with the IEP team to make changes. If the parent and the IEP team cannot reach an agreement, the procedural safeguards afford parents other options such as mediation and the right to request an independent educational evaluation, an IEE, which is like getting a second opinion. The request for an IEE can be made verbally or in writing, and the school must respond to the request within 7 calendar days of receiving it. A parent is entitled to one IEE at public expense each time the school conducts an evaluation with which the parent disagrees, and parents can only request an independent educational evaluation, that IEE, after the school completes an evaluation and the parent disagrees with the results. The district has 2 choices on how to respond to a parent's request for an IEE. The school may either grant the request for the IEE or file a due process complaint to request a hearing to show that its own evaluation is appropriate. If the district grants the request for that independent educational evaluation, it's completed at no cost to the parent and is conducted by a qualified examiner who's not employed by the school district responsible for educating the child. The school either pays for the full cost of the evaluation or ensures that the evaluation is provided at no cost to the parent. The school must also provide information about the criteria regarding credentials of qualified examiners, where an IEE may be obtained, how to get reimbursed, reasonable and expected costs, and that parents are not restricted to choosing from the sources provided by the school district. They can choose their own evaluator. The school may ask what the parent's objection is to the evaluation. However, a school cannot require an explanation of the objection, and it cannot unreasonably delay either providing the independent educational evaluation at public expense or filing a due process complaint to request a hearing to defend its evaluation. Parents have the right to have their child evaluated at their own expense at any time. The IEP team must consider the results of the evaluation if the parent provides them. If the child is found ineligible for special education services, there are other options under the procedural safeguards that I'm going to talk about next. At Michigan Alliance for Families, we discuss 5 tools for resolving special education issues. These range from informal to formal processes. The first option is having an informal meeting. This tool keeps the people closest to the problem, solving the problem, and can be the fastest way to resolve the issue. If a conversation's been happening between you and the teacher or therapist and you're not able to resolve the issue, it might be helpful to bring in a principal or special education administrator to join the conversation. Informal meetings allow you to discuss your concerns and issues relating to your child's education with the IEP team. You can review and revise your child's IEP as needed. You don't need to wait for the annual IEP team meeting. Another option is a facilitated meeting. This can be any structured special education meeting, including but not limited to an IEP team meeting, a manifestation determination review regarding discipline and placement, or a meeting to address behavior concerns. The difference between a facilitated meeting and an informal meeting is that there's a trained, neutral third person who facilitates the meeting. The facilitator keeps the discussion focused on the student's needs, addresses and diffuses conflict, and makes sure that all voices at the table are heard. A third option is mediation. Mediation can help resolve disagreements related to the student's educational program, including topics not specified in the federal special education law, the IDEA, such as communication. During mediation, a neutral third-party mediator guides a confidential discussion of the issues. The desired outcome for mediation is a legally enforceable written agreement, but whether there's agreement or not depends on the participants. If an agreement is reached, a written agreement is drawn up by the mediator that addresses how the issue will be resolved. Facilitated meetings and mediation are both voluntary. Both the parent and school must agree to participate. A mediator or facilitator can be provided for free through Special Education Mediation Services, also known as SEMS. They use mediators trained in special education law through local dispute resolution centers. The next 2 options are more formal processes. A state complaint is a written complaint that's submitted to the Michigan Department of Education, Office of Special Education. When filing a state complaint, you're alleging that the school district has violated state or federal special education rules or regulations. Therefore, their determination will be whether the district was in compliance or not in compliance. It's not about right or wrong. From the date the complaint is received, the final decision must be issued within 60 calendar days. The Michigan Department of Education, Office of Special Education will investigate, typically through documentation and interviews, to reach a final decision. If the final decision includes violations, a corrective action plan must be developed to address the violations. There is no appeal to a final decision for a state complaint. The most formal option is a due process complaint and hearing. Due process complaints and hearings address issues related to identification, evaluation, eligibility, placement, a free appropriate public education, FAPE, and a manifestation determination review decision about discipline and placement. An administrative law judge is assigned. A resolution meeting is required unless the parent and the school district agree to waive it or the district files the complaint. A resolution meeting is one more chance for the parties to try and resolve the issues before going to hearing. If the complaint goes to a hearing, the administrative law judge will conduct an administrative hearing. Witnesses will testify under oath and can be cross-examined, and the parties present exhibits and documents and make opening and closing statements. The school district will be represented by their attorney. Parents may be represented by an attorney, but it's not required. The administrative law judge issues a written decision and order. With a regular due process hearing, a decision and order is issued within 45 calendar days following a resolution meeting. The more formal the process, the further you get away from the people closest to the problem solving it. The more formal the process, the longer the time frame for the resolution to be implemented. Each of these has a place in resolving disagreements. Make sure that you are using the one that serves your child to get the best resolution. Adult learners with disabilities ages 18 to 26 retain their right to special education and related services if they have not received a regular education diploma. This includes young adults who are enrolled in adult education, alternative education, and transition programs. Initial evaluation procedures and timelines to determine an adult learner's eligibility for special education and related services are the same as they are for younger students. In establishing the initial evaluation process, school districts have the flexibility as they adapt to the unique needs of adults. The process should emphasize providing the adult learner with information about their disability, evaluation process, special education supports, community supports, educational options, and self-determination so the individual can make an informed decision. I want to share some brief information about the special education re-evaluation process. Your child's needs may change over the years, so after the initial eligibility for special education related services, a re-evaluation must occur at least once every 3 years unless parents and school agree that a re-evaluation is not necessary. Re-evaluations can occur more often when the school determines the education or related service needs, including improved academic achievement and functional performance of the student, warrants a re-evaluation, or when a parent or teacher requests an evaluation. A re-evaluation may not occur more than once a year unless the parent and the school agree otherwise. Parents and schools may agree a re-evaluation is unnecessary to determine if a child continues to have a disability and needs special education and related services. In this case, that review of existing evaluation data should be completed. A parent can change their mind at any time and request a re-evaluation. The school must then complete the evaluation or provide the parent notice about why the evaluation is unnecessary. Before stopping a student's special education services, a school must evaluate a student with a disability unless the student is exiting school due to graduation or aging out. So just some key takeaways from this video. A thorough and individualized initial evaluation is the first step in determining if your child qualifies for special education and related services under the Individuals with Disabilities Education Act. And it's helpful to understand the laws, procedures, and timelines involved in the evaluation process, and knowing that if you disagree with the school's evaluation, you have the right to request an independent educational evaluation at the school district's expense. Communicating effectively and working together with the school team will help ensure your child's needs are being addressed in school. Thank you for tuning in to this video about special education evaluation and eligibility. If you have any questions, please don't hesitate to reach out to your regional parent mentor. They can be reached by phone at 800-552-4821 or at info@michiganallianceforfamilies.org. Our regional parent mentors are located around the state and live where they serve. They are ready to support you and answer your questions. We also have a statewide Spanish-speaking parent mentor and a statewide Arabic-speaking parent mentor. If you want to connect with us in other ways, we are active on Facebook, Instagram, and of course, YouTube. Michigan Alliance for Families is an IDEA grant-funded initiative of the Michigan Department of Education, Office of Special Education, the Michigan Department of Lifelong Education, Advancement, and Potential, and Michigan's Federal Parent Training and Information Center, funded by the U.S. Department of Education, Office of Special Education Programs. Thank you for tuning in and have a great day.